Introducing the all-new Velotric Discover 3 e-bike. Designed for comfort, powered for hills and distance. From the first turn of the pedals,
All right, testing. 1, 2, 3, check. We've got contact. 1 minute. 1 minute, people. Let's see. Let's move this.
Good to know. Session. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, Lauren Hunt, David Sturgill of the state, County Attorney Jeff Gray, and Chris Ballard are also present.
Good afternoon.
Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. And as you note, the microphones on your tables are turned off, so please come to the lectrum when you're addressing the court. Second, the court will address the camera and still photographer, camera operator and still photographer. And if you both could come forward, please, to the lectrum. All right, could you both state your names?
John Wilson, KSL Television.
Tess Crowley, Deseret News.
Good afternoon. Could you state your roles for today's hearing?
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court's standing decorum order?
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulties complying with the order?
No.
Thank you both for your cooperation.
Yeah.
As we begin this afternoon, the court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone in the courtroom may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during their hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Faumina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael
Mr.
Bird for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner, also from the ATF.
All right, and to both parties, thank you, I
Thank you.
appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge.
Just want to highlight one issue for the court because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. And so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge.
Your Honor, the state has received the proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right, well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right, does either party require the benefit of the record before we begin? To the state.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles really at this stage. One is a gatekeeper role on admissibility, And the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102b3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the.
If you want your car to look brand new, be sure to use this.
Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that's conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So, in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly. And because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those three issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there is a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
I just need some other tables besides 3 so we can try.
All right, if you, all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on, and if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up, because that could cause a delay. I just want to knock this out first. Yes. Where would that TV go? If that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV. Again, transparency needs to be viewable, not just there in concept. All right, yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right.
I need them to actually plug in their HDMI.
I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Mr. Ellis is plugged in.
All right. Let's take a look here. I appreciate the parties' patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
We're working on it right now, Judge. Yes.
All right, and on the screen monitor here, it looks like something came up. All right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go? Just bring it in and go ahead and we'll get started. And how much time is needed for that? Well, let's go ahead and proceed, and then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right. Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Agent, if you wouldn't mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
A total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
It's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
No, it's been constant since then.
I want to talk about a bit about your training and experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer Involved Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI Public Corruptions Task Force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a FARO certified. It's a 3D FARO scan of crime scenes.
What's a FARO scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm I've been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have 2 case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about what we've... So as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City Airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the 2 pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents within SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
Did you mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms.
My dad never looked back at his old jeans after I gifted him these.
Trust me.
And so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, then he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
You're just going to do the redacted version.
Thank you.
And that may happen a couple more times as we go through exhibits
I
because of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview room in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
That's correct. Yeah.
So we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Oh, that's probably right.
It has no audio, so we would like to admit and publish it at this time.
All right. State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with has like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
Was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George the St. George court office courthouse there. They met and discussed briefly. Just kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
All right.
And how do you know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down. Sorry, Judge, if I can just have a moment.
You may.
I apologize, Your Honor. I misspoke. It's not 14.1, it's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, State's Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
If I may approach.
You may. Thank you. All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was it was found on the computer science building, on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile, and it was a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up when fired. It still had the bullet projectile in the end, and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall it happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but.
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Joel Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution, from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
That's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep, yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not. I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it, and how we have given it in discovery to defense is it's a video. Audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it. That they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each.
InSinkErator garbage disposals are built to last. We're the only leading brand with heavy-duty DuraDrive induction motors. And we put those motors
Admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into Evidence States Exhibit 16?
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right. And in regards to this exhibit, is in the, as State's Exhibit 16, is there any portion of that recorded statement that occurred before the the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, turning to the defense. Mr. Novak.
Thank you. Thank you, Ms. Hunt. So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 1102 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I am not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. And in fact, today, we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it would probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it till we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because the state, because the exhibit contains significant content that is not admissible even in a preliminary hearing. So I'm going to stop now, but I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before I go to Ms. Hunt. So going to your first point in regards to what this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that. But I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
Oh, no,
I
it's
just
fine.
want to categorize it and put it in a box. So what is the objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here.
Sure.
Because there are two exhibits that I'm very confident are coming. There are portions which are not relevant. There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Okay. Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably, for counsel, a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits, there are no disputes, these exhibits, there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do, I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the As I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing, and then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closer analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important, so this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. We take that important. We recognize that its importance, we take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests, and on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right. Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument a sidebar, because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
Then we would like to have a very brief closed hearing to lodge another objection about the publication of this, of any portion of this exhibit, of certain portions of this exhibit beyond Your Honor's eyes. That's what I'm saying.
thank you. All right. Right now, what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed. So on the next step, when I make my ruling, the court is ready to go.
Okay,
And
fair enough.
maximizing the time, because we also want to put up a monitor. So there's like 3 things we can accomplish in the space of 15
Fair
minutes.
enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer. Just I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there. Court is in a brief recess.
All right.
Very interesting, very interesting, very, very interesting. The trial is going to be very interesting because that's where the rubber's going to meet the road. To me, the evidence has holes, a lot of holes. Also, there's holes in the testimony, like the Barney or Fred Flintstone Hare cop who said that the cops are just ejecting a bullet out of their rifle and just leaving it on the roof. And that's standard. It's what they do because they carry the gun around cruiser ready, meaning there's no bullet in the chamber when they have the gun in their car. So that means when they get the gun out of the car, they have to put a bullet in the chamber. Now, they didn't shoot the gun, and they're going to go back to the car. So while they're still on the roof, they're just going to take the bullet out of the chamber, bump, and let it fall on the roof and just leave it there. And that cop said yesterday in the testimony, that's normal, that's routine. No, it's not. No, it's not. The cops are not leaving the bullet. And why is he going to take it out when he's on the roof? To prep his gun to go back into the car. So that whole, scenario doesn't even, it's bullshit. It's bullshit. It's not routine, like the guy said yesterday, for cops to clear the chamber and let the bullet just go on the ground and just leave it there. Nobody does that. You pick it up, okay? 100% of the time, you're picking it up. So it's just That's just one thing that I can poke holes in. I mean, it's I don't know. It's just going to be interesting. Who doesn't love a good trial? You know what I'm saying? Who doesn't love a good trial? The prosecution has to be honest. You know, that's part of it. So when you see all these holes and this grainy footage, you know, and you've got a cop. Oh, it was the shape of a gun wrapped in a towel. Yeah, okay. So it's going to be a great trial. It's going to be a great trial because I think he does have a good defense team. We'll see. I mean, there's only so much that they can go after during this prelim, so you know, I think they're doing fine in making the points and the objections they need to. It's going to be good. It's going to be good. Good trial.
Game or something, because the official story doesn't add up. And Patel killed investigation into foreign involvement in his death. The governor and the FBI said, tear up the concrete where Kurt got shot as fast as you can and scoop it away and pour new concrete in. Why would you do that? If there wasn't bullet fragments or something down in there, what are you covering up? I mean, you know the drill. I'm going to get to that later in the fourth hour, and excerpts from the trial yesterday, excerpts today. We'll probably spend 30 minutes on that, and more's coming out because the trial's ongoing. So look for that in the fourth hour today. We're also going to be looking at the Canadian government that's passed all these laws. They're totally tyrannical, to ban Bible verses being read, to spy on everyone, arrest people for pre-crime. Canada considering suing citizens who criticize the government in social media. Got all this video in the UK where you'll have a street preacher literally just reading from the Bible, saying the wages of sin is going to hell, so they get arrested. I mean, it's just wild, the level of tyranny. Speaker Johnson says House GOP is looking at all angles to legislatively kill the anchor baby scam and birth tourism racket after Supreme Court ruling protects citizenship for children of illegals. The plane can land, and the woman's having the baby, and the kid gets citizenship, all the welfare, and she gets to stay. Very dangerous. Founders did not intend that. It's very clear it's unconstitutional, but you saw what the court did. So we hear we're going to pass the SAVE Act to secure voting and have voter ID. We hear all this stuff from Johnson, and now we hear this, and there's several laws they could do that would cut money off from these people because they control the purse strings. That's the system we have, legislative, judicial, and executive. But they've not been doing their job. It's been a terrible Republican Congress, and it's gotten worse since MTG and others got ran out of there. So we'll be looking at all those developments. A lot of criticism of the new head of DHS saying he's not accelerating deportations enough. They have beefed him up some, but nothing compared to what we need to do. But at least it's not Biden totally flooding us. I mean, they shut down internal enforcement because the left was rioting so bad.
I want the outside of my home.
I don't think that was really the right move to make.
And to stay that
Trump
way.
thought it was a loser
That's
with the
why
voters, so
I went
he
with
killed
LP
that.
Smart Side
We'll
trim
give you
and
updates
siding. Because if I'm
all
outside,
of that.
it's not to
As
work
well,
on
the Democrats
house.
are clashing
That's
over who
why
replaces
it's only LP for me.
Plattner. And I've now read the case and what the woman says.
Is your boss's scream.
And I first just saw that she said, well, he was my boyfriend for a few months, and he was drunk once and forced himself on me. And then she makes him breakfast, and she's with him another month. And then she never accuses him of that until now. And then the only text message she has to a friend saying, yeah, he can be a little aggressive in sex. And now that I don't like this guy. I mean, I love seeing, Democrats fail, but the Republican senator he's up against might as well be a Democrat. My point is this Me Too stuff's a fraud. And the Democrats are just, a snake eating its own tail. It's a circular firing squad. But I want to delegitimize the Me Too thing because even the police will tell you over half the rape allegations that they investigate turn out to be fake. And, this guy says he's innocent. Well, like E. Jean Carroll, will this lady sue him? Will she win a civil judgment for $80-something million? First a $5 million, then $80 million judgment because you're not allowed to say you're innocent? Of course you're allowed to say you're innocent. So it's just very, very dangerous. And Nick Fuentes was eloquent on that point. Again, I'm going to play that clip next hour before he joins us talking about that. But she does it for years and years and years and years and years and years and years, say that he assaulted her sexually. And all she's got is one text message to her girlfriend saying, yeah, he can really be pushy and aggressive. Okay. Did you call the police then? I mean, again, folks, none of this makes any sense how this happens. Meanwhile, you've got convicted pedophiles having surrogate women have babies for them, and then they get caught raping and they don't even get in trouble. Meanwhile, I've got all these cases in the U.S. where if a white man or woman is murdered by somebody that's not white, they get probation. Same thing in Europe. I mean, it's open season. They're going to let the guy go that killed the Ukrainian immigrant lady, stabbing her in the neck, and nobody helped her. They're going to let him out. So I just, it's wild that, no, it's open season on you because of what color you are. People say, oh, well, you're learning what racism is like. I didn't do jack crap to people in my 52 years. I was brought up a Christian, brought up to be colorblind, brought up that if some people are more disadvantaged than you and, you know, didn't have a chance, you know, that you want to try to help them. And then because of what color I am, because I'm white, technically black folks really aren't black, they're dark brown. I guess some in the Congo really are black. And a striking look, that black skin with the white teeth and all of it. I think it's kind of interesting, but I'm kind of pink like a gecko. So, and people ask why I'm so red. I got a little bit of Native American in me. My dad tans real well. I got 4 kids. 2 of them don't even tan. They got porcelain skin. It's beautiful. They're white. But me, I get any sun. I am red. I like it. But man, I've not even gotten that much sun. If I really went out, I turn deep brown red. So I really am kind of a red man, aren't I? That little bit of Native American sure does the trick. But we'll be getting to all of that as well, and so much more today. But I wanted to go to this before we hit more news. When I say this could change the world, when I say this is the future, when I say this is truly revolutionary, I mean it. The cashless society, the internet ID systems, the social credit score will not be able to be put in place if there are transportation companies that don't comply, if there are banks and credit card processing systems that don't go along with it, if there are telephone and telecom and VPN companies that'll protect your identity. And there's a giant market for this, and it's been developing and unfolding. But I've been hearing for years when we would get debanked, we always wanted a backup. We've had this particular company for 9 years, almost 10 years. And I always wanted backups, and we would get backups, and then the left would attack them, and they'd dump us, even though we had very low chargebacks. Before I got deplatformed, I had the highest credit rating in corporate stuff you can have. We had like a 1.3% credit card rate. Nobody can even get that because we had almost no chargebacks or returns. And we could never get a backup. I always wanted a backup. And we could never get one for more than a few months. And imagine that being 10 times worse. That's what the head of the UN says. It's what BlackRock says. It's what the WHO, the UN, if you don't have your vaccine passport, says. This is what the WTF says. This is their holy grail. It's what the head of the central banks of Europe have said. They want to control your behavior with these systems. That's why whether you're a small business or a large business, you need to understand. I mean, I remember when Bongino said, oh, here's my sponsor, I'm part owner or whatever, just like 8 years ago. No matter what your merchant account is or, debanking, if you are legal and good, we will take you. They wouldn't even return our calls. Everybody else, I mean, it's bull. Or they charge you these huge rates. These are good rates. This is revolutionary. And this is a little secret I'm telling you. These are the folks that I've been using and staying on air for 9 years. I'm not going to have time to air it all. It's a special announcement, but here it is. I am about to reveal something that is one of the most revolutionary ideas I have ever talked about on air. And in the future, it's going to be the most revolutionary idea. The entire future battle that humanity faces against the globalists.
Roller coaster in here. Keep up. I'm coming back for sure.
Thinking about owning a business but not sure where to start? With Mr. Electric's proven electrical franchise model, business ownership is more accessible than you think. Our experts can help guide you from startup financing options to operational coaching. Ready to build something of your own? Let's make it happen together.
Mark of the beast social credit score system will be fought on this battlefield. I'm talking about debanking. I'm talking about deplatforming. I'm talking about the globalist war, not just on the nation state and the family and the individual, but on small, medium, and even large businesses they don't control. That's the real undeclared war that is intensifying across the planet right now, and America is the front lines. This information is revolutionary, and this is the keys to success and being independent from this predatory system. I'm about to break it down right now. My fellow patriots, the first thing the globalists and the leftists do when they want to silence you is go after your merchant accounts, go after your business payment systems. It's that simple. They try to cut off your ability to even receive money or make payments. It's globalist siege. It's globalist economic warfare. It's a globalist blockade, an embargo, sanctions against American populist patriots. For everyone that's been watching and listening to me for years, you've seen the attacks, you've seen the deplatforming, you've seen the court battles, the news articles, the demonization, the bogus default judgments. We even have FBI and CIA operatives on hidden camera talking about how their entire goal was to take me out at the knees by knocking out my ability to accept payments. And that model they used on me, they admit, is for all of you.
Alex Jones. Yeah, so we were after him.
You are? Are you still after him?
Yeah.
Why?
Because he's broke. He got found guilty and had to pay like $100 million.
So why were you after him?
We're not anymore.
Just to get the money from him?
Yeah.
Didn't pay anything, don't have money.
Case used. Was that a CIA?
Sure it was.
So with Alex Jones, and the goal with him was what? Just to bankrupt him?
Oh, pretty much.
Well, because of First United Payments and your support, they failed. And they failed because I had a processor with a backbone who loves America and believes in the free market. One who stands up for American justice and who didn't back down when they received threatening messages and pressure from other major institutions. If you are a conservative business owner, Google is watching you. Meta, Facebook is watching you. Amazon, all of the major big tech is watching you. If you think for 1 second that they are not orchestrating and coordinating their efforts behind the scenes to take you offline and out of business and render you harmless to the system and the machine, you are wrong. The question is not if, it's when. Stripe, Shopify, PayPal, Square, they're all part of the same big tech machine. Consolidation, vertical integration, that is the goal of the BlackRock globalist system. Because once there's only one central system, they can bring in the universal credit score. This is the key to their entire panopticonic takeover plan in their own words. The head of BlackRock, Larry Fink's been very clear. Once they have this system in place and they're close, they are going to shut down everybody that isn't part of their system, even people that aren't political. This is about total control. They just got to get to the patriots that are opposing them to get to you. And FirstUnitedPayments.com stands directly in the tyrant's way. My fellow Americans, this is your call to action. Call or email First United Payments now and ask them how you can protect your business against the globalist predatory attacks and shutdowns today. Visit First United Payments now at FirstUnitedPayments.com. That's FirstUnitedPayments.com. And talk to a real human here in the good old US of A by calling toll-free 877-899-1313. That's 877-899-1313. Or go to FirstAmericanPayments.com. The tyrants are counting on us not to innovate. They're counting on us not to migrate to institutions and organizations that are pro-human just like us. This isn't some new company. I've been using them for almost a decade. They're already taking care of most of the patriots. Whether you're a florist, have a gas station, or you're a farmer, or you've got a little 5 and dime shop or a factory, whatever it is, online merchants, this is the place for you. They're the only ones that have withstood all the attacks. We always tried to have backups. Would have a couple backups. We lost dozens and dozens of them and dozens of banks, but not First United Payments. These guys are patriots and they're in our corner. They're Americans just like us. We're extending America's 250th mega sale, the biggest in the history of the AlexJonesStore.com. That means this Monday the 6th and Tuesday the 7th at midnight Central. The biggest sales ever. Buy one, get one free. Up to 60% off the best-selling supplements, Patriot Apparel, 50% off, and more. Take action now at the AlexJonesStore.com. Have you noticed all the big universities and corporate media and governments around the world run down America all day? That's because the American system stands against their globalist system. And as the public figures that out, their corrupt, tyrannical, oppressive, communistic, anti-human death cult can't compete with what America stands for. And we stand in the shoes, on the shoulders of our forebears. Whether you're black, white, Hispanic, old, young, if you love liberty and freedom, and if you want to be free, and if you want to control your own destiny, you believe in meritocracy, then America is for you. It's under attack because the idea of it stands in the way of the enemy. And America is a dream. Just like a dream to get married or a dream to start a business or a dream to write a poem or write a song. And when you do that, those dreams come true. But we have to breathe life into those dreams. They want to kill those dreams. Don't let them break your will. Be proud to be an American and know people around the world still love America and understand it's the globalists that have hijacked us, and we're in the process of taking our country back from the Chi-Coms and the Israel lobby and the globalists at Hollywood and the left and all of them. And that's why it's so important to support the next leg in the info war at AlexJonesLive.com. And, of course, at the AlexJonesStore.com with the widest selection of Patriot Apparel, the best supplements, collectible knives, the best water filtration, and more that will empower and enrich your life while keeping this beacon of truth on the air as we accelerate into the future and as the Great Awakening prepares the final defeats of the globalists and their Great Reset. I salute you all. This is 1776 2.0. We're unstoppable together. God bless you all. Take action now.
Days, weeks, and even years ahead of the news cycle. AlexJonesLive.com is tomorrow's news today.
And it's time for humanity to stand up and say, I don't know what's going to happen at the end of this, but you want to fight, you better believe you got one.
In the festering heart of the D.C. swamp, where loyalty to foreign powers trumps fidelity to the American people, Senator Mitch McConnell's condition remains shrouded in secrecy following his June 14th hospitalization after being found unconscious.
Desiree Townsend here again outside of George Washington University Hospital as we mark week 3 of the hospitalization of Senator Mitch McConnell following the June 14th
national security alarms. Why abandon a critically ill husband for CCP powwows unless orders from headquarters demanded it?
So his wife, Elaine Chao, was found in China 3 days after he went into cardiac arrest. So we're trying to figure out where she is. It doesn't look like she has come back to the house. So I was wondering, have you seen her at all?
No, I haven't seen anyone.
The rabbit hole deepens with the eerie 2024 drowning of Chow's billionaire sister Angela in a Tesla that reportedly locked and reversed into a lake. Another accident amid whispers of family leverage and silencing. McConnell, long derided as China Mitch, props up a Senate machine terrified of a pre-August 3rd vacancy, which would trigger a special election that could empower outsiders like Thomas Massie to seize the reins. The plan is blatant and equally seditious.
The likelihood that Senator McConnell is on life support in some way, shape, or form is actually supported by multiple studies, which puts the 30-day survival rate of an 80-year-old after an out-of-hospital cardiac arrest, now mind you, he was found at his home, at less than 5%. Now, you need to understand who
the reports are. He's
they
brain dead.
are. See, Senator Mitch
There's a typo
McConnell
yesterday when we
has
said he's dead. I
lot
said
of enemies.
brain
He's
dead, but
not
I
well
forgot to
liked
put the
by
brain dead
people
in the
on
headline.
both sides of the aisle. In fact, the lack of disclosed health information and him potentially still being in the hospital on life support has actually united this country in shared outrage. Republicans want him removed because he kept blocking the SAVE Act. Democrats don't like him because he previously stacked the Supreme Court. And it doesn't appear as if he had much support from President Trump either, based on past Truth Social remarks. So with that in mind, they really is just one person, his wife. And largely, this is also based on the law. It's very likely he had either an advance directive or a living will. Even without either one of these legal documents, nearly all of end-of-life decisions typically fall on the spouse in almost every state. So when everyone says there is really only one person in my mind, and that is Elaine Chao.
Drag the turtle shell past the deadline, and the Uniparty preserves its safe seat while unelected staffers wield Mitch's vote, as we have already seen with other debilitated absent members of Congress. J.D. Vance, as Senate President, and the State Department owe the public immediate transparency. Is McConnell alive, vegetative, or already gone? DC's rot is so pungent, even Honolulu catches a whiff. John Bound reporting for the Alex Jones Network at alexjoneslive.com.
All right, folks, we'll be right back on the other side with the full transmission. Nick Fuentes.
Introducing the AquaPure Ultimate Water Filter Shower Head. You're not just drinking tap water, you're showering in it, breathing the steam and soaking your skin in it every day. When you take a hot shower, that hot water opens your pores and creates steam. That means chlorine, lead, and many other contaminants in your tap water can hit your skin, your hair, and the air you breathe inside your own bathroom. And unlike most shower filters on the market, this has independent third-party testing. SGS testing showed a 95+% lead reduction using the system, over 99% chlorine removal, and many other chemicals. The system installs directly onto a standard shower head. It literally just takes seconds. No plumber, no tools, no modification to your plumbing. Regularly $139. Today you can get it for just $97.99. That's 30% off. VIP members at thealexshopstore.com get it for as low as $69.99. That is beyond a steal. Secure yours now while supplies last at thealexshopstore.com.
Discover trends and global developments years before they happen, right here on The Alex Jones Show.
By the door, fell in love with a Choctaw maid over in a Georgia store. Elijah, ooh, standing there, don't never let it show. She don't ever answer yes or no.
Well, since the weekend, it's been one of the top, if not the top stories on X, on Instagram, on Facebook, on Fox News. And that's Sneako, who's this popular influencer who constantly says he's left-wing, right-wing, joined Islam 3 years ago, and declared everybody will be under Islam soon in America. We're going to take you over. There is a second great crusade coming, and the Crusades was a response to 700 years of Islamic invasion. And I've got an MIT professor, I never got the clip yesterday, I'm going to play it coming up today in this segment. And he's explained to Muslims, Spain won't let us have mosques because they're evil, but America is letting Islam take over, so is the UK. Well, that's because you took over 2 million white slaves out and sold them on record. That's because you were there 700 years and killed millions of people. That's because you took over much of Europe as well. And then they teach in the history books that we launched the Crusades for no reason in the 1300s. No, Islam by the time of Muhammad's death, had already taken over much of what Saudi Arabia, and by 100 years later, had taken over the entire Middle East and much of Africa. And by the time of the Crusades, 400, 500, 600, 700 years later, they pushed all the way into Poland, pushed all the way into Russia, overrun Serbia repeatedly, taken over Sicily, almost took the Vatican 3 times, huge wars, invaded Rome. But the public is so historically ignorant about this and historically illiterate that then they have all these Ridley Scott movies about the Muslims being victims, the Crusades being evil. And you think people in England, thousands of miles away, wanted to get on horses and ships and come over and fight the Muslims? It was because they kept attacking and enslaving everybody. It took a bunch of countries helping Spain, who only kept about 10% of the north, hundreds of years. It took them 300 years to retake Spain. Muslims are lucky they're even allowed in Spain or in Poland or in Serbia. And I don't want to attack Muslims in general. I know some have reformed and want to be part of the West, but the real Muslims, the Orthodox Muslims, they're not the radical Muslims. They are the Orthodox Muslims want to take over. Then you got Israel wants a wider Israel, greater Israel, and wants us to back that. We need to stay out of it. We need to cordon it off. We need to contain it. Like a septic tank. You don't bring your septic tank into your living room. It's out in the yard. It's contained in a tank. And we don't need Israel running us. We don't need the Muslims running us. We don't need the Chi-Coms running us or BlackRock or the UN or any of this. No more. We run our country, and other nations do. And then we work with other nations unilaterally, bilaterally. We don't have a global government. We don't have a global UN with a NATO army. We don't have an unelected EU commission that says, oh, all the cars have to have cameras that watch you now inside of them. That's the law here now, too. Think how far we've gone. 14, 15, 16 states, they keep adding new ones, have passed laws down to age 12 and 13 that the kids are in control of their own medical decisions, but the state really makes the decisions, taking parental rights. They now had the Federal Court of Appeals say forced injections should start nationwide, starting with the Amish. I mean, we're not out of the woods here, folks. These people are coming down on us. This is Big Brother. How does anybody argue? Well, is Alex Jones right? Is he exaggerating about Big Brother? Is he, he lies about stuff. But these people, I saw CBS National News, NBC National News, wasn't even looking for it. Just all this week, national TV attacking me. Jones is crazy. He's a liar. Don't listen to him. And they never say what I say that's a lie. I'm here showing you what they're doing. So I've been inviting Sneako on the show. And he called up, he was talking to the producers during the break, and he said, well, Alex is being mean to me, but I didn't talk to him. I got this second half of the producer, but she's very accurate. He said, Alex has been really mean to me, but I'll be polite and nice. I want to have a nice discussion with him. And I told him to tell him, yeah, sure, have him on. He goes, well, you need to come on my show. And I said, when? She calls him back 7 o'clock tonight. Well, I don't have a lot of medical issues. But I've been lifting weights a lot and everything, and I got a tendon issue on my left arm with my shoulder, and I got this kinesiologist that comes over every few months. It's very painful. I can also go to their office, but that's during the day. They do house calls if you pay them more. And this lady will absolutely get my tendons back in line, and I can lift weights again and feel great. Don't need any surgery. She's going to stick her fingers in there, and it makes me almost cry. It's excruciating. It takes about an hour. She's going to work on both shoulders. This one goes out too. It's on the verge of it. And I'm sorry, I'm not going to cancel my kinesiology hour-long thing of torture for the other torture of going on with Sneako, but I'm happy to do it. He said he can't come on my show today, but I can go on his show at 3. Well, I have other stuff to do at 3 and other commitments, but I might cancel those for Sneako. We will be talking about Sneako coming up because he's indicative of an American with an American accent who's going to Mecca and putting, wearing hijabs like he's a woman with the Palestinian, colors, and just hopping around. And most people haven't seen the video of him in New York. They saw the one where he said, we're taking over. Islam's going to dominate you if it's Allah's will. Every house will be under our control. He also, in the same event, but nobody really saw that, is slitting throats and saying, we're going to get you and all this stuff. And this is the group that's been doing that more than anybody. This is the religion that makes you submit to it. The Jews will barely even let you join their group. You got to flip over backwards and stand on one leg and go through 14 flying fiery hoops. Christians all fight with each other with their 10,000 denominations, and they're trying to get you to join. There's been some cases where Christians got out of control and persecuted people, but that's not Christ-like. But that's not been going on for hundreds of years. It's Islam where it's officially we're taking over. That's God's will. So I followed this report last night, and I'm not going to play the whole thing here, but this goes right at Sneeko. These are the points I'm going to bring up to him when he's on air. He also says Elon Musk is dumb. You know, so what? You got a rocket ship company, a spaceship company. Oh, you're dumb, and you're a migrant. You know, what are you doing saying deport me? He contributes to this country. He's not saying he wants to overthrow it and put in a monotheistic religion that could execute your wives and daughters and pedophilia and marry 9-year-olds. And you got all the stuff going on with Muhammad. You know, his secret power in the Quran and in the Hadiths is 30 black men from Africa with giant penises rode him through the night and gave them the magic seed. I'm not kidding, folks. And they believe that semen made him have the strength of 30 men. He's a superhero. Spider-Man gets bit by a spider and becomes super. You know, Deadpool gets radiated and becomes super. Superman, our son, makes you more powerful. You know, usually something traumatic makes you more powerful. Well, in this case, it's gallons of African semen. That's quite the profit, I have to tell you. I didn't, I guess that he'd be really popular in Hollywood right now. And I guess that's something Sneeko is interested in, reportedly. So we want to talk to you about the Sneeko. We look forward to talking to you. But let's go ahead and go to my report on Sneeko.
He's doing the citizen vigilante thing. Alex Jones is indirectly calling for people to kill me. He knows it. You know it. His audience knows it.
Over the weekend, influencer Sneeko enraged America and what's left of the Western world when in New York City, marching with a bunch of Muslims, he declared that we will all be under Islamic rule. Every home will be Islamic. Every Christian church will be shut down. We will be their slaves. And then he came out and said that my opposition to him was a death threat when it was no such thing. We're about to break it all down right now, and his adventures trying to be like Muhammad in the Al-Zut.
Takbir! Allahu Akbar!
Well, here you see Sneeko a few days ago showing Islamic jihadists massing and preparing for their military actions against the West. And of course, he got a lot of universal hatred for coming out and saying, soon you'll be forced under Islam in every home to serve Allah, and you will be basically slaves of the Islamic cult, which the Quran says it's a battle manual to take over the world. Now, really, he's just a rich kid from Connecticut, but he's decided Islam's taking over, so he's joined Islam, and now he's really angry at myself and Elon Musk for coming out and saying we should deport him to one of the 50-plus Islamic countries around the world if living under Islam is so incredibly wonderful. And, of course, this year, Andrew Tate revealed that he and Ye won't associate with Sneeko because he, according to them, tried to have sex with them.
And he asked me what I think about cucking and if it's normal to explore your sexuality and if I've ever tried it. And I said, look, I'm older than you, bro, and I've never tried that. I don't think that's normal. And then he started saying, isn't it normal just to try new things? Don't you think it's normal to be curious? How do you know if you're really gay or not unless you've tried being gay? And then I realized he was coming on to me.
But like when I was like 14, I thought I was gay. I watched gay porn.
Nigga, you gay. And when I realized he was coming on to me, I thought the best thing I can do is just not talk to him anymore.
So I guess if you study what the Prophet Muhammad did, he reportedly got his secret magical powers from 30 virile black men filling his rectum with gallons of semen. I'm not kidding. Look it up. So in a way, not only is Islam all about pedophilia and marrying 9-year-olds, it's also about taking gallons of semen in your rectum. So, I mean, in a way, I've got to say he's a true Muslim.
Takbir! Allahu Akbar! Oh no! This is the Islamic Republic of New Yorkistan. Islam will will be in every household. Inshallah, the whole world is Muslim. Welcome to Mamdani's New York. You see this city? You see how it looks? Inshallah, your city looks just like this too.
But we're going to move on from Sneako's quest to be like Muhammad when he wrestled with the 30 black men and they rode him, according to their top Islamic text, to one of the most classic statements we hear all the time, that Europeans never invented anything. Europeans have no culture. Well, he says that so what if Elon Musk has a spaceship company, only the most successful ever, the most innovative ever, launching more satellites and ships in the last 10 years than all of their space programs, public and private combined. He says, big deal. You've got the most successful spaceship company. That doesn't mean you're smart. It's easy to become the richest man in the world. Listen to this young punk.
You retards think Elon Musk is smart. He's building a rocket ship, dude. He's tweeting all day about Muslims. He's trying to incite a race war, an African migrant into the U.S. with an entire Indian team trying to incite a race war in Europe. Oh, he built the rocket ship. Look how I read him like a book.
I think Elon Musk's going to talk about. I think Elon Musk's going to mention it. And
I read him like a book. Genius. Oh my God, he smoked weed with Joe Rogan. Oh, there's a spaceship in his profile picture. He's the warrior for free speech, calling for an American citizen to be deported for speech. You stupid idiots. Read him like a book. There are scripts. It's so easy to figure them out. Their only ideology is hating Islam. One day before he calls to deport me, I said here on Discord, he is going to chimp out about that tweet. Of course he would. Because he's not smart. And you're an idiot for believing he's smart. Because he speaks like a robot.
He knows a threat when he sees one young.
The guy doesn't know anything.
Sith.
An average computer software engineer talks at a space with him and makes him look like an idiot. Guy's owned by Mossad and he's a trillionaire. Richest guy in the world is a slave. And you're going to die over money? Money is what buys you? Richest guy in the world doesn't even have his own voice. He's a little puppet for Epstein. And you're going to die over money? It's nothing. Wallahi, it's nothing. None of that is going to help you in the grave. None. Trillionaire. Played him like a freaking fiddle. The richest man in the world is afraid of me. Is afraid of me.
No. I want to address the so-called death threat.
He's doing the citizen vigilante thing. Alex Jones indirectly calling for people to kill me.
I said, none of this is meant as a threat. I want no harm against Sneako. I said the analogy is we're told it's Islamophobia. Well, most of us have an innate fear of stepping on the edge of a 50-story building. That fear is ingrained in us because if you fall off, you die. Or if you see a rattlesnake or you see a black widow spider, you get scared and you want to step on it because you understand it's a threat. I don't want to physically step on Sneako. I want to get my foot dirty. I just simply am stepping on the ideological lies of him when he says he's going to plant his flag on us and enslave us. But I love him playing the victim and, sitting there like, oh, all these people are just coming after poor little him and mean old Elon Musk who, he's a foreigner, even though he's a U.S. citizen. What does he contribute? He just has millions of employees. I mean, the truth is, it's very healthy that the world sees through Sneako and realizes what a disgusting fraud he is. And I picked up a big honeycomb limestone rock, and I said, watch this. And I threw it about 15 feet perfectly and splat on the head. And my daughters went, Daddy!
He's doing the citizen vigilante thing. Alex Jones is indirectly calling for people to kill me. He knows it. You know it. His audience knows it. They feel threatened by the truth. And against American values, they don't want discourse. They don't want democracy. They don't want free speech.
You think normally I could throw away 10 feet perfectly, splat the head? You think normally I could throw a rock perfectly and splat the head? No. It's the defender in me. And you have instincts, too, that you can turn on and you can hone. And Sneako, I'm not calling for splatting his head, but culturally, I'm calling for putting him nonviolently in an airplane like a cannon, a clown in a cannon.
I saw this from Sneako. It's very sad. It's very sad. He seems to be joining up with Hassan Piker and Zohran Mamdani. And it's like I said last week, just because I don't like Israel doesn't mean I'm a communist. Okay? That. I saw last week all these DSA candidates won their election, and each one is more anti-American and radical than the last. And that's not like a GOP talking point. They're talking about abolishing ICE. You know what that means? Amnesty for 12 million illegals brought in under Biden. So no, just because I don't support genocide and a war with Iran, just because I don't want AIPAC to buy all the elections doesn't mean I'm a communist that wants to abolish the police and the prisons and ICE and legalize weed and abortion and free all the George Floyds from prison and have them wreak havoc on our free buses and free subways and free grocery stores and take all the money from white people and give it to them. I'm not a communist either. And you know what? The DSA is growing in strength. They're going to have like a dozen members of Congress next year. They're making inroads in city councils and state legislatures. The DSA is the enemy, okay? And contrary to what these anti-Israel people say, they say left and right is an artificial divide. That is not true. That is something promoted by the left when they want you to go along with their agenda.
Nick Fuentes, who is joining me at 1 p.m. tomorrow on my Wednesday show at AlexJonesLive.com. That's today. Has been exposing Sneako for a long time because he got to know him. And he's absolutely right. This Islamic alliance with the Democrat Socialists of America, the Communist Party, is pure poison. The Red-Green Alliance is one of the greatest threats facing America. Now, in closing, I want to show a clip of Dan Bilzerian, who I had on the show recently. And I'm not an enemy of Dan, but I got to say, what a cheap shot. I'm not going to play the whole long video because there's dozens of examples. But I'll just play the very first of it and just one example of it not being true. And as soon as I saw the clip, before I even saw the proof it was a lie, or maybe Bilzerian's hiding under a rock, I knew it wasn't true because I've seen Nick on these very shows he mentions bringing up Israel and directly talking about Jewish supremacy. So it's not true. So here's Bilzerian saying, have you noticed now that Nick finally got big and finally got on CNN and finally got on this channel and finally got on Piers Morgan that he won't talk about Israel? That's basically all he talks about is Israel. If I've got any criticism of Nick Fuentes and other people, is it's Israel, 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 Israel. When we have Islam, we have the Chi-Coms, we have BlackRock and the globalists, which you can say is Israel too. But the point is, Nick's now being criticized because he is warning about Islam, which I have been saying is a great thing. So here's just a little bit of disproving what Bilzerian says. But none of you even need me to tell you that. You've seen Nick on all these shows tearing Israel a new a-hole. But here's Bilzerian. This is the type of cheap shots and, quite frankly, I think the type of jealousy we're witnessing.
3 months ago, he went on every major podcast in America and talked about the left is coming to kill us, the blacks, this, that, just all the typical Fox News shit, not the crux of the issue, which is Jewish supremacy. He just didn't speak about that on any of these podcasts. Look, I get it. If you don't want to talk about that on every podcast, it might get boring. I get that. But to not mention it on any of the mainstream stuff, he's been waiting his whole life to get on Piers, to get on Tucker, to get on
no, our shows are bigger than theirs. Bigger than
doesn't
Piers.
Say a word about the most important
issue.
I mean, you have to talk about, there's a concept of Jewish peoplehood. It's the sense that they are part of a common nationality, a common tribe, a common people. And so where they reside in Israel, the United States or Europe or elsewhere, they see each other above or maybe on a different level alongside their nationality, their state, wherever they reside. If they're in Germany, France, the United States, they see themselves as part of a transnational nation, of an international nation. The Jews in America, the Jews in Israel, they identify as Israeli or American, but they also have something in common. They identify as part of a common nation, which I would say there's a world Jewish population. It's world Jewry. And world Jewry has representatives. There is such a thing as the World Jewish Congress, where they actually elect, it's democratic, all the local Jewish organizations elect representatives to represent proportionally the Jewish population in their area at the World Jewish Congress. And it's sort of like Davos. It's like the World Economic Forum, but it's exclusively for members of the Jewish nation that exists across the world.
But we had to close out with one of the other videos shot in their big Islamic We're Taking Over celebration last weekend in New York with Sneako doing the classic Islamic We're Taking Over and we're going to cut your head off. So listen, Sneako, why don't you go join ISIS? Why don't you go join Al-Qaeda? The U.S. government under Biden put the head of Al-Qaeda in charge in Syria. I mean, why don't you go join the Iranian military right now? Hell, I've told Netanyahu his son shouldn't be glamping around and sugar tanking around and candy assing around in Miami. He should go join the IDF. But remember, the IDF said they're not going to do ground troops into Iran. They want us to. Yeah, they're going to fight Iran until the last dead Iranian and the last dead American. The truth is, Orthodox expansionist Islam for hundreds of years has been funded by British intelligence, then the CIA starting in the 50s. All right, the full report is at rumble.com/The Alex Jones Show Live and X through all shows. We got him saying he's going to slit our throats on there. We'll be back with all the other news and Nick Fuentes. Stay with us.
And a microscopic tag be implanted in a person's body to track his every movement. There's actual discussion about that.
And often they're things you don't know what to do with. UBOs, they're called, unidentified bright objects.
Can brain scans be used to determine whether a person is inclined toward criminality or violent behavior?
Who's got the brain that's going to be most susceptible to a particular kind of manipulation?
So the point is, they've been obsessed with this. It's going on. The COVID shots implanted the matrix graphene oxide to grow. It's now being scanned. It's now being read. They were putting chips in the troops 30 years ago. The revolution's already here, is what you're saying, Jesse Beltran.
These are just chips on a size that you can no longer see. They're nano size, once 2,000 times the width of a human hair. The graphene oxide, the silicon-based materials that have been in, we know for a fact that they were in the mRNA. We know that Dr. Ido Bachelet signed a contract with Pfizer in 2015 when he did that TEDMed talk with 1 trillion robots in a 1cc syringe, and how he teaches his students how to, once they're in a host, how to control them with RF emissions.
And you heard Colin saying 21 years ago that, oh yeah, when we're doing scans, we find all these chips, these bright objects, ha ha ha, wonder to put them there. But as you said, you've been doing this 20 years, and about 10 years ago, you began to go away, not seeing chips anymore, but just liquid emulsion nanotech. Here you are 6 months ago or more, scanning me. Let's go to Alex Jones getting scanned.
So if you put that camera in there, you see how it says probably silicone? That means it's an electronic component. And it's not unusual to find that in the posterior ear area.
So wait, I got a higher reading than him?
No, his was higher than yours.
Okay,
yeah,
that's good.
Yeah, but you did get a positive reading there. So you are getting at the base of the neck is what we typically see. Scapula area. What we're finding is after post-COVID, this is very typical. We're completely bombarded by this stuff.
From your own research, there are compounds naturally in nature that just do absolutely incredible things that will draw out these type of things. But you guys have come up with one with scientists that adds these special sea minerals in that then even drags it out even more. And so I have been taking this, the dreams I've had, my skin, my health, what it's done is absolutely insane. GetMasterpiece.com. Matt Hazen, tell us what this does, and people can get 10% off when they follow the URL, GetMasterpiece.com, or use promo code Alex when you're there on the site, because this is really special.
Zeolite is an incredible mineral that is known as what's called the master binder. And what that means is it's known to pick up every type of forever chemical, toxin, toxic heavy metal there is, including fluoride. So when you see charcoal or carbon or clays for binders, you don't see that they will pick up fluoride. Zeolite's different. Zeolite also gets the fluoride. That's a very big deal. It is great at removing these environmental toxins from our body. Masterpiece is the highest grade sea mineral plasma solution. It is basically isotonic, the same mineral composition as your blood plasma. So the sea minerals are being carried in by the nanometer, sub-nanometer size clinoptilolite zeolite, and once the toxin hits the zeolite, it releases and displaces the mineral. People don't feel bad. There's no normal detoxing reaction.
Everybody needs to go to GetMasterpiece.com. You get 10% off by using that URL automatic when you go. There's promo code Alex as well. GetMasterpiece.com.
waging war on corruption. It's Alex Jones.
I want to finish up with the Islamic invasion, and that's not hype. That is the Quran that I've read twice, and then I've read excerpts of hundreds of times since, here on air many times. The whole damn thing is a story of conquest and how to take over the world, and how to lie and cheat and steal and enslave. Now you can put everybody in sex slavery if they're your enemy. They can deal us drugs, everything else. Does that mean all Muslims are like that? No. Does that mean I want to exterminate them all? No. But I am not converting to their religion. I'm not putting up with it. And then upwards of 90% of military Jamels coming in, 90+% never get jobs and are on welfare, standing around in their tracksuits and their nightgowns. And now you got Zohran Mamdani, more popular than Netanyahu among Jews in major poll. This is insane. But it is a false equivalency to say, well, if you're against Islam, you got to be for Israel. No, I don't. And I'll be getting more into that with Nick Fuentes. But I got a bunch of news I want to hit. Before we do that, this is finally it. And the only reason it's extended to 3 p.m. today is because I was supposed to cut ads for the news.